Scroll Toyota, leading the way every day. And Scroll Toyota, symbols of trust.
Motion being hijacked by some outside.
Excuse me.
Curtis Vandevelde, the attorney for former marketing manager Bernadette Meno, and port management attorney John Bell went at it last night over access to Meno's medical records.
This is crazy to be arguing about these things without seeing her medical record. That's completely unfair.
Again. Now, this
People,
is
when they put their own medical,
outside.
I don't understand why I'm allowed to be interrupted and not even finish my point.
Meno, along with 6 other employees and former GM Mary Torres, were all sacked in December of last year amidst allegations that they all participated in a conspiracy to falsify a workers' compensation claim that was made by but never paid out to Meno, who filed the claim after she said she slipped and fell in a port bathroom. Last night's hearing was over an April 15th port request for an order from the Commission requiring Meno to produce medical records that, Bell said, are evidence of a pre-slip and fall visit to a doctor by Meno for treatment of a condition the port alleges Meno claimed was caused by her fall.
We have on good information from a medical professional that Miss Meno was seen for an MRI for basically the same injury 2 days before she says she slipped and fell. Now, considering the circumstances of this case, and I think everyone's kind of gets the gist of it now, you know, she's accused of committing fraud.
I'm going to object. I'm sorry. I'm going to object. I'm not going to dignify their efforts to weasel through someone else to get my clients, to get information about my client that they identify as an anonymous source. There's no testimony. There's nothing that was presented to the executive director about the source of this information.
He's talking about management illegally weaseling into her medical history. She's filed a claim for well over, I'm sorry, she hasn't filed a claim. She attempted or tried to weasel through a claim for well over $100,000 in benefits. We were informed that she had an MRI 2 days before she says she slipped and fell for basically the same thing that she's claiming, oh, you know, I'm injured. And again, this is for the hearing on the merits. But when you have that kind of evidence, I think the Commission would want to know that. I think the Commission has a right to know that, and I'm just arguing that the Commission has the discretion to know that.
There is an ongoing investigation by the Department of Health and Human Services, and they're going to take action on this HIPAA violation by which they procured medical records belonging to Ms. Meno without appropriate relief. It wasn't done by subpoena, wasn't done by a proper authorization.
We have nothing to do with that thing. This whole HIPAA thing, that doesn't apply to the port. That does not apply to management. It does not apply to the Commission. He's made that misrepresentation before, and it was wrong the first time he made it. It's wrong. It's still wrong today. HIPAA applies to medical facilities.
If anybody can show me where it is that it refers to what Mr. Bell is now talking about inside of the moving papers, I'll sit back and I'll withdraw my objection. But it isn't there. And this is improper argument under your rules, and I'm telling you that this will only exacerbate what is already a HIPAA violation.
You don't get a free shot at committing fraud. So I'm not asking you to assume that we're right. I'm not asking you to assume that she committed fraud. I'm asking you that if our allegation is that she committed fraud, and there's clear evidence that we're right, that the Commission not be deprived of that evidence.
The employee is entitled to notice of all evidence that is intended to be used against the employee and an opportunity to refute the same in writing with affidavits and otherwise relative to any adverse action that would lead to termination. If you allow them to go on and obtain records outside of it, you're really denying what the law says.
The Civil Service Commission agreed with Meno's attorney and denied Port Management's request for Meno's medical records. Acting CSC Chairman Manny Panawan.
Only the employee who suffered the adverse action may inspect documents, serve interrogatories, and conduct depositions. Further, there is no reciprocal authority for management which took the adverse action to conduct any such similar discovery.
Kevin Kerrigan, PNC News.
I do not.